Welcome back to Justice Redesign. I'm Steve Teske, retired judge. I'm your host. And this is Act 2, okay? And this is called The Settlement That Forgot the Constitution. Now, if this were an ordinary lawsuit, the Trump versus Trump, this is the point where everybody packs up and goes home. Case dismissed. Nothing more to see, except that's not what happened. Instead, the lawsuit suddenly disappeared and the settlement suddenly appeared. Folks, I've been practicing law for 35 years. I've prosecuted cases. I've defended cases. I presided over thousands of cases as a judge. I've approved settlements. I've rejected settlements. I've sent people back to negotiate better settlements. I've seen some creative lawyering over the years, but I've never seen anything quite like this. Because this wasn't just settling a lawsuit. This was settling a lawsuit that the court was about to ask whether it had any constitutional business hearing in the first place. That's why it got settled so quickly. Think about that timing. The judge asked, do we even have adverse parties? And suddenly everybody decides, you know what, let's settle. Now, I'm not saying one caused the other. I'm saying if this were a movie, you'd tell the screenwriter the plot twist was too obvious. Okay. And then the settlement became public, or at least parts of it. And that's when I realized we weren't watching a settlement. We were watching a constitutional magic trick. Because apparently if you dismiss the lawsuit, you also, dismiss the judge. No judge, no courtroom, no constitutional questions, no awkward discussions about whether you're essentially negotiating with yourself. Problem resolved. It's brilliant. It's also why magicians don't usually become attorneys general, by the way. Then came the part that honestly made me laugh out loud. Not because it was funny, because sometimes the only response left is laughter. The Department of Justice announced what it called an anti-weaponization fund. Now, let's just stop there. Can we appreciate government naming for a moment? Washington has a remarkable talent. Nobody names anything what it is. The Patriot Act, the Inflation Reduction Act, the Affordable Care Act. Congress names legislation the way Hollywood names action movies. Everything sounds like it should have dramatic music behind it. Now we have the Anti-Weaponization Fund. That sounds less like a legal settlement and more like the Avengers retirement plan. Come on. Except here's the part that deserves our attention. And this wasn't monopoly money. This was approximately $1.8 billion in taxpayer funds, not to repair bridges, not for veterans, not for disaster relief, not for schools, not for law enforcement. The stated purpose was to compensate people the administration believed had been harmed by what it described as the prior administration's weaponization of government. Okay. Now, forget the fact that the Department of Justice in the U.S. Attorney's Office has a unit, a division called, weaponization. Okay? Blows my mind. But now whether someone agrees or disagrees with that premise isn't my point. That is the whole thing about weaponization or the anti-weaponization fund. My point is this. Who decides? Congress? A court? An independent commission? No. The executive branch. President Trump. Which means the same executive branch making the accusations who also decide who gets compensated. That's an extraordinary concentration of authority, folks. And constitutional systems generally become nervous whenever one branch starts investigating, prosecuting, judging, and compensating all at the same time. You've got three branches of government and you've just now collapsed them all into one. That's not separation of powers. That's one-stop shopping. Then I discovered something that made the story stop being funny altogether. Buried alongside the settlement was this addendum, this one page, one signature, Todd Blanche's signature. And according to the reporting surrounding the agreement, that addendum would have provided sweeping protection from future IRS civil actions involving President Trump, members of his family, and related business entities for covered tax matters predating the agreement. Now, think about that for just a second. The plaintiff receives immunity from the agency. The plaintiff ultimately controls through an agreement signed by the plaintiff's former personal defense lawyer, who now serves as acting attorney general. Folks, that's not a conflict of interest. That's an entire family reunion of conflicts. If conflicts of interest had a convention, this would be the keynote speaker. Now, before somebody emails me saying, hey, Judge Teske, aren't settlements supposed to resolve disputes? Well, of course, absolutely, they are. That's exactly what settlements do. But settlements don't erase constitutional principles. You don't get to say, well, we solved the conflict by eliminating the conflict. That's not how Article 3 works. That's not how legal ethics work. And frankly, that's not how common sense works. Imagine two Little League teams. The umpire walks onto the field before the first pitch. Both coaches walk over together and announce, hey, we've settled the game. We decided we're both the winners. Now we'd like the parents to buy the trophies. Folks, that's not a settlement. That's collusion with snacks. And then the backlash started, right? Not just for Democrats, not just for constitutional scholars, Republicans, former government lawyers, members of Congress, people who rarely agree on anything suddenly found themselves asking the same question. What exactly just happened? When politicians who spend most of their time disagreeing begin agreeing that something doesn't look right, you should probably pay attention. Eventually, Todd Blanche announced that the department would not move forward with the anti-weaponization fund. At first glance, that sounded like the story was over, except the court didn't think so. The judge refused simply to dismiss the injunction. The thing that said, you can't do this anti-weaponization fund. Why? Why did the court refuse to dismiss it? Because announcing you're not pursuing something today isn't the same as telling the court you'll never pursue it tomorrow. This was a smart judge. And judges, quite understandably, prefer permanence over promises, especially when constitutional questions remain unresolved. There's an old saying among lawyers, hard cases make bad law. I'd like to suggest another. Conflicted cases make confused institutions. Because what we've been watching isn't merely one controversial settlement. It's something much bigger. It's an institution trying to convince itself that independence can survive without independent judgment. And that's where this story changes, because up to now, we've mostly been talking about documents, settlements, court orders, constitutional clauses. But institutions don't make decisions. People do. Lawyers do. And the next question becomes the most important question of this entire series. Where were the lawyers? Who would have walked into that room, looked around, and quietly said, we can't do this? The answer is the story we've really been telling all along. They're gone. They're not there. Ladies and gentlemen, that concludes Act 2. Until Act 3, coming up, y'all be safe. Take care. Bye.